requests that they limit noise or side conversations that might adversely affect the project. The court is also required to caution attorneys, parties, and any witnesses about disclosing confidential or personal information. That would include things such as Social Security numbers, the typical personal type of information that we often have. By consenting to a video recording in accordance with the guidelines promulgated by the Judicial Conference Committee, neither party is agreeing or consenting to the public nature of materials as to which they have previously asserted a privacy right or as to which there is a legal privacy right. Materials of a personal nature that are an invasion of privacy should not be shown or disseminated further in these proceedings. Is the United States ready to proceed?
We are, Your Honor.
Who will act as lead counsel and lead spokesman for the United States?
That will be me, Your Honor. Tony Arvin, Assistant U.S. Attorney.
And who is with you today?
Your Honor, my case agent is Deputy U.S. Marshal Scott Sanders. And for the initial proceedings regarding the handwriting, our handwriting expert is Mr. Grant Sperry, S-P-E-R-R-Y, Grant Sperry. But he will just be here through the first part of the case.
I understand. And who will be the lead spokesperson for Mr. Thomas in the case?
I will, Your Honor. Jennifer White from Winston & Strawn.
All right. And Ms. White, who will be participating with you today?
Well, I'm joined by Mike Passano from the Federal Defender's Office in the Middle District in Nashville, Tom Lane from Winston & Strawn, Karina Bogachu, also from Winston & Strawn, and Ken Riley from Winston & Strawn.
All right. Will you be speaking primarily?
I will, along with Karina and Ken.
Right. When a different person speaks, because of Ms. Parker, and to make sure we have the names correct, and since we're not as familiar with everyone, I need the person to initially simply remind, it's not Ms. White, we know you are, but if everybody else would remind us of who they are, at least the first time, and that way we'll get it correct in the transcript.
Yes, Your Honor.
All right. Is the United States ready to proceed?
We are, Your Honor.
Do you wish to make a brief opening statement? And it may be that we would start with Ms. White, but do you wish to make any opening statement?
Your Honor, I do not. We've already filed briefs on this case. This is a case in which the defendant is alleging ineffective assistance of counsel, and the court has set a hearing on those allegations.
Exactly. That's correct. Ms. White, did you wish to make any brief opening statement?
I did. But, Your Honor, if I can for a minute before I give that opening statement, Mr. Arvin and I agreed to the entry of certain exhibits into evidence with your permission.
Fine. Let's go through those if you're ready to do that, if that's helpful.
Yes. I prepared a list for you. I don't know if you'd like to see it.
How many exhibits are there?
Between 30 and 40, I believe.
The government had filed a brief list of exhibits the last couple of days, but this is different.
Your Honor, my exhibits will come in through the witnesses. There will just be a few, but I've reviewed the exhibits the defense wants to put in and have no objection to those.
Could you pass it up and let me take a look? If it's often helpful for them to come in contextually, that is, with a witness, if there's a witness from whom they would be received. So I'm not quite sure. The context, even in this type of proceeding, is sometimes helpful.
Well, I think we intend on using them also with witnesses for the most part. There are some on here that Mr. Arvin and I had agreed they're prior transcripts from a prior proceeding. And
let me suggest this. Because you've listed a composite, or I think a composite exhibit, maybe not, are you intending that we would add exhibit numbers on the left-hand side of the page for items such as the case file for Mr. Irby?
Yes.
That would be Exhibit 3, for example.
Yes.
Now, is Mr. Irby actually going to testify? I know he's listed on the government's list of potential witnesses. Is he actually going to testify?
Your Honor, I'm sorry, I didn't hear what you said, Mr.
Is Mr. Irby actually going to testify?
Yeah, Mr. Irby is subpoenaed by the defense, and I think they intended on calling him in their case. And
all right. I think he was on the list of potential witnesses.
He is, Your Honor.
Contextually, in order to assist in following everything, it is more useful for the exhibits to be introduced through the witness who's presenting them. Now, if you have witnesses that, if you have exhibits that are going to be stipulated to, as to which no witness is going to testify, then it's okay to admit them usually at any stage or at the end of the proceeding or at the beginning. Let's do it this way. Let's reserve this list. I think it's useful, and it'll be useful to Mr. Warren. And then, as the witnesses testify, let's put the exhibits in that would come in through that witness. And then if you have stipulated exhibits at the end that have not had a witness, we can simply mark them at that time. That way they'll come in, and if someone's looking at them sequentially, the exhibits will coincide with the testimony.
Okay, that works for us, Your Honor.
That's the way we'll do that. All right, then the United States may proceed.
Your Honor, this is the burden is on the defendant.
It is. I wanted to know, but you did send me a witness list. Let me ask this. Are you actually going to call anyone in the case?
The only one I'm sure I'm going to call is Mr. Sperry, Mr. Grant Sperry. The other ones,
and you
perhaps
did indicate
Mr. Irwin.
he was going to testify at the first, so I didn't know if you'd agreed to a sequence of witnesses.
We have agreed, Your Honor. Mr. Sperry has a prepaid trip tomorrow, so we've agreed that
That's what I was
they will
asking.
put on their handwriting expert, Ms. Pierce, first, and right after that we'll put Mr. Sperry on. And
That's all I was asking about, was understanding when you were going to present
Yes.
your expert on handwriting.
Thank you, Your Honor.
I have some opening remarks, if that would be okay.
That's
Your Honor.
perfectly fine. This is the appropriate time.
May I approach the podium?
Absolutely, no problem.
Thank you.
Yes, ma'am.
Thank you. On April 21st, 1997, Loomis Armored Car Guard James Day was shot and robbed as he exited a Walgreens store carrying the store's deposits. A year and a half later, Andrew Thomas, the defendant in this case, was convicted of that crime, as well as for being a felon in possession of a Mossberg shotgun purchased days after the Walgreens robbery. What we intend to show in this proceeding is that due to the ineffective assistance of Robert Irby, Mr. Thomas's trial counsel, the jury that convicted Mr. Thomas did not hear all of the evidence that it should have, and in many cases, it heard evidence that it should not, and that this could have made the difference in whether the jurors had a reasonable doubt at Mr. Thomas's trial. For example, we intend to show that, number one, Mr. Irby failed to challenge the joinder of count 3 of the indictment, which was not related to counts 1 and count 2, even though there were 2 separate and equally compelling reasons to do so, allowing the jury to hear inflammatory evidence that was inadmissible as to that count. 2, Mr. Irby failed to investigate the testimony of his alibi witness before putting her on the stand, despite his concerns about the truthfulness of her testimony, allowing the jury to hear evidence that she was lying. And number 3, Mr. Irby failed to investigate and present the defense that another individual, Bobby Jackson, committed the Walgreens robbery with Anthony Bond, meaning that the jury did not hear this exculpating evidence at trial. I'll begin with the evidence that but for Mr. Irby's errors, the jury would not have heard. Mr. Thomas was charged on a 3-count indictment. Count 1 for the robbery of Mr. Day. Count 2 for using a firearm during the commission of that robbery, and count 3 for being a felon in possession of a firearm. Critically, the firearm that Mr. Thomas is alleged to have possessed in count 3 is not the firearm that is alleged to have been used during the commission of count 1 or count 2. Rather, count 3 refers to the firearm purchased by Mr. Thomas's ex-wife 3 days after the armed robbery alleged in count 1 and count 2 occurred, and the indictment makes no efforts to draw a connection between the 2 separate crimes. Count 3 of the indictment reads as follows, quote, on or about April 24th, 1997, in the Western District of Tennessee, Andrew L. Thomas, having been convicted of a crime punishable by imprisonment for a term exceeding 1 year, that is, did possess in and affecting commerce a firearm, that is, a Mossberg 12-gauge shotgun, serial number K742634, in violation of Title 18 United States Code, Section 922G, end quote. that the indictment did not allege that Mr. Thomas's supposed acquisition of the Mossberg firearm was related to the armed robbery in any way should have raised an immediate red flag for Mr. Irby, because it is on the face of the indictment which courts focus in determining whether charges have been properly joined under Federal Rule of Criminal Procedure 8A. But Mr. Irby failed to challenge the indictment on the grounds that it was facially deficient and the counts had been improperly joined.
Where did the funds come from to purchase the Mossberg?
At trial, it was alleged that the funds came from the robbery, from the Walgreens robbery.
They also sought to prove that he purchased an automobile later.
Yes.
In fact, it was the next day, I think it was. Is that right?
It was either later that day or the next day, but he wasn't charged with any crime relating to that.
Right, but both would be evidence of the use of the funds.
Yes.
Or the availability of funds that might not previously have been available.
Right. I think the point that I'm making here is that on the face of the indictment, that connection wasn't made, so that the indictment was facially deficient. Mr. Irby also failed to challenge the joinder of these offenses under Federal Rule of Criminal Procedure 14A, which allows severance when the joinder of offenses in an indictment appears to prejudice the defendant, even though much of the evidence of counts 1 and 2 could easily be confused as convincing evidence of count 3, despite the fact that such evidence was inadmissible as to that count. As a result, the jury heard evidence of all 3 counts at once, and indeed, the United States evidence on counts 1 and 2 was emotionally charged and easy to confuse as proof of a felon with a gun. It included Mr. Day in a wheelchair recounting the events of his robbery and shooting, and the repeated playing of a jarring surveillance video, which showed, as you, Your Honor, described during Mr. Thomas's sentencing hearing, quote, the way in which the crime was committed. It was cold-blooded, intentional, designed to inflict death or permanent injury, end quote. All of this evidence was shown to the jury, while the United States presented virtually no evidence on count 3. Their entire case was based on the contradicted testimony of Angela Jackson, that although she physically purchased the shotgun a few days after the robbery, and although she filled out all the paperwork in her name, she did this for Mr. Thomas. We will hear from Mr. Irby whether there was a reason why he did not object to the joinder of offenses on either of these grounds, though we cannot fathom a conceivable tactical reason.
Do you agree that the government would have been able to introduce the evidence as to the shotgun purchase to show that the defendant had acquired funds through the robbery? That was some evidence of that.
That would be evidence of counts 1 and counts 2.
They would have introduced, it would have been the same evidence that it was a shotgun purchase, so they would have heard the same thing.
But evidence of counts 1 and counts 2, that evidence of count 3 would have been admissible also to prove counts 1 and counts 2, right. But the evidence of counts 1 and counts 2 wouldn't have necessarily been admissible for counts 3. So, for example, the videotape or Mr. Day's testimony wouldn't prove whether or not, wouldn't go to the issue of whether or not Angela Jackson had purchased the gun from Mr. Thomas. And that evidence that's the evidence that's really emotionally charged, seeing Mr. Day in the wheelchair in the courtroom and him testifying to the events of being shot and being robbed, and seeing it played over and over on the videotape, which, as you, Your Honor, noted, was a pretty shocking videotape. So that evidence wouldn't necessarily be admissible to count 3, but is sort of easy to confuse because the jury is seeing a shooting, they're seeing a gun.
It's a different gun.
It is a different gun.
Everybody in the South would know that it's a vastly different type of firearm.
Perhaps. I don't know. Certainly, being from New York, I wouldn't, but I don't know.
Okay. All right.
Okay, so just picking up where I was, so we can't conceive of a tactical reason why Mr. Irby would fail to at least challenge the indictment on either grounds, either facial deficiency or that it was, that the evidence was prejudicial to Mr. Thomas. There can be no question that Mr. Irby's failure to challenge the indictment was prejudicial to Mr. Thomas, who at the age of 25 received a life sentence under count 3, even though the maximum penalty under counts 1 and counts 2 was 25 years. Turning now to counts 1 and counts 2, Mr. Irby presented an alibi defense that Mr. Thomas could not have committed the Walgreens robbery because he was with his girlfriend, Dana Wiggins, at her home at the time. We intend to show that even before putting Ms. Dana Wiggins on the stand to testify, Mr. Irby suspected that she wasn't being truthful, and yet he did nothing to confirm that she was at home with Mr. Thomas on the day of the robbery and not at work. Had Mr. Irby done even a cursory investigation, he would have learned, as the United States easily did, that her employer's records show that Ms. Wiggins was actually at work that day. Instead, the jury listened as Mr. Thomas's key witness was completely discredited by the United States.
My recollection may be incorrect, but that Mr. Thomas was very anxious that Ms. Wiggins testify, that he was very concerned and wanted Ms. Wiggins to testify, and maybe it's incorrect, but I think, what if the client was very insistent that the person testify?
That wouldn't absolve Mr. Irby of his duty to investigate, especially if he had doubts, especially when he's seeing the red flags and he knows something's off. But even if he hadn't seen red flags, he still has an obligation to investigate the case, and his defense and his witnesses and the government's witnesses are still a duty to investigate. So instead, the jury listened as Mr. Thomas's key witness was discredited by the United States, who called Ms. Wiggins' employer to testify and present documentary evidence, including timesheets for April 21st, 1997, sales that had been made that day in her name, and her paycheck to show that she had been paid for April 21st, 1997. These damaging revelations, which could have been completely avoided had Mr. Irby made the most basic efforts to properly investigate Ms. Wiggins, completely gutted the defense's case. Not only did it destroy Mr. Thomas's alibi defense, which was his main defense at trial, but it also gave the jury reason to doubt Mr. Thomas's entire defense. Now I wanted to turn to the evidence that Mr. Irby failed to present and which the jury therefore never heard. The United States' case was based on the theory that two people had committed the Walgreens robbery. Anthony Bond, who told the investigating officers that he drove the getaway car, even though his fingerprints were found on the passenger side of the vehicle, and Mr. Thomas, who Mr. Bond told police had shot and robbed Mr. Day. Like Mr. Thomas, Mr. Bond had been indicted on counts 1 and counts 2 for armed robbery, which carried a 25-year sentence, but he pleaded guilty, he testified against Mr. Thomas at trial, and he received a reduced sentence of 12 years. But there was significant evidence that another individual named Bobby Jackson, and not Mr. Thomas, had been Mr. Bond's true accomplice in the Walgreens robbery. And we intend to show that Mr. Irby had this information right at his fingertips. We will introduce a letter from Mr. Irby's file from Assistant U.S. Attorney Tony Arvin informing Mr. Irby that an eyewitness to the Walgreens robbery had identified Bobby Jackson as one of the perpetrators from a photographic lineup, and that Bobby Jackson had been arrested for committing another robbery of a Loomis armored car guard in the months following the robbery and shooting of Mr. Day. Furthermore, Mr. Arvin provided Mr. Irby with open discovery, allowing him complete access to the investigatory file. We will show that Mr. Irby's file contains the fruits of this discovery. He has FBI reports showing that eyewitness Robert Fisher actually identified Bobby Jackson as the getaway driver twice on 2 separate occasions. His statements from other eyewitnesses describing the driver of the getaway vehicle as heavy-set, a description that does not match either Anthony Bond or Mr. Thomas, but that does match Bobby Jackson. And he has a letter from one of Bobby Jackson's cellmates, a man named Stephen Briscoe, who wrote to Mr. Arvin that Bobby Jackson had been bragging that he had committed multiple armored car robberies. Despite knowing all of this, Mr. Irby failed to investigate or present a defense at trial that Mr. Bond's true accomplice was Bobby Jackson, though once again, it's difficult to imagine a reasonable strategic reason why he would not do so. We will now present the evidence of this defense that the jury never heard. We will present evidence that Bobby Jackson confessed to committing a robbery that occurred 3 months after the shooting of Mr. Day at the South.
You don't have evidence that he ever confessed to committing this robbery, correct?
No, we do not have that evidence, but yeah.
That seemed clear from the papers.
Right, yes. But I don't think that it's necessary for us to show that he actually...
No, it just seems important.
Okay. Yeah, it's important, but it doesn't go to the question of whether or not Mr. Irby presented the defense.
Should investigate. For you.
Exactly. We will present evidence that Bobby Jackson confessed to committing the robbery that occurred 3 months after the shooting of Mr. Day at the Southbrook Mall, when he, accompanied by a man named Terrence Lawrence, pulled a gun on and shot at another Loomis armored car guard in the hopes of stealing the money that he carried before fleeing the scene in a red car, a crime that bears a striking similarity to the to the shooting and robbery of Mr. Day. We will present the details of this crime from Bobby Jackson and Terrence Lawrence, and we will introduce testimony from Mr. Lawrence that the Southbrook Mall attempt had not been his first. Mr. Briscoe will also tell us that he notified the U.S. Attorney's Office of this, and he wondered why no one ever contacted him to follow up with what he knew. We will also hear from Gail